you had mentioned earlier, you said you don't get a do-over when you're doing an appeal. You said it has to be an error of law. And I want you to give an example or several examples of an error of law so that we can understand what that means.
Sure. So in law school, we've all learned about standards of review. And at the trial court, you have standards of proof, right? So criminal is that the prosecutor has to prove beyond a reasonable doubt. In most civil cases and in injury cases, it's preponderance of the evidence, which means 50% more likely than not. At the Court of Appeals level, if you're dealing with, there are several different standards of review. The one that's best for the appellant, for the person who's appealing the decision, is de novo, meaning anew, which is that has to do with interpretation of an area of law. So, for instance, something that's interpretation you cut that out. So, interpretation of statutes, for instance, or interpretation of of common law, as in what the court has said. So, for instance, if we're looking at the Missouri Human Rights Act, which is much like Title VII or the Civil Rights Act, prohibiting discrimination on certain bases, right? So we've all heard recently in the past couple of years about what on the basis of sex means. So one thing that has been an issue is, what does the word sex mean? So does it mean gender? Does it mean gender identity? Does it mean biological sex? Does it mean sexual preference? So recently, the Supreme Court of the United States came out with a determination that I think they did that sexual preference, so sexual orientation, was a basis on which employers could not discriminate. But a question is still in the works as to transgender litigants and whether being transgender is encompassed within that meaning of sex as it is in the statute. So that is de novo review, meaning that the Court of Appeals will take different opinions, will take different arguments and different opinions and kind of determine what that word means or whether the trial court correctly defined it in the case below or not. More commonly, so that's de novo review. More commonly is the Abuse of Discretion Standard, particularly in Missouri, which is extremely hard to meet. And this is an issue I have frequently with people wanting to appeal a case. So you asked me initially about what happens, about why it's not a do-over. But people come to me and say, hey, I don't like what happened. I want to go to the Court of Appeals. And the abuse of discretion standard means that the lower court basically abused its power, abused its discretion. And I've often, when I was teaching, I likened it to, there was a Seventh Circuit opinion where the judge said to find an abuse of discretion, the court opinion below must hit us as wrong with the force of a 5-week-old unrefrigerated dead fish. So
okay.
I know. I'll throw it in there on occasion, but then you can't do it too much because it's like, okay, she's always going to use this. I actually explained this to my daughter, who said, actually, Mom, it should be like a 3-day-old unrefrigerated dead fish because by 5 weeks the fish is completely disintegrated. I said, okay, fine, you're too smart for me. But so that's what I tell people, is I say, is it so wrong that it is wrong with the force of a 5-week-old unrefrigerated dead fish? And in Missouri, the standard is for under abuse of discretion is that there was not substantial evidence to support the decision, or it was against the weight of the evidence. That's a different challenge, which means that even if there was enough evidence on the record to rule the way that the court did rule, the evidence supporting the other side was so overwhelming that the decision was against the weight of the evidence. So these are very, very hard challenges to meet.
Okay, I'm going to stop you there. I want you to give me an example of de novo, just a real life example of a de novo, whether it was your case or not, and a real life example of abuse of discretion?
Well, I gave you the de novo one.
Oh,
That's the
right.
sex one.
Okay, yeah. Sorry,
Yeah,
my bad.
interpretation of statutes, let's say, yeah. And well, actually, I'll give you one that I did in Missouri. Okay.
All right.
It didn't actually get filed, but I used to, and still do on occasion, write briefs, kind of ghostwrite for the ACLU in Missouri. So one question we had was about parenting rights. So it was two female partners, and one of them had given birth to the child, and then they never got married, even after gay marriage was legal. So there are two ways to become a parent in Missouri and in most states, and either one is biologically and the other is by adoption. So if you don't do either of those, all you really have, according to the statute, is you can file is nothing. You have no parental rights. You can file for visitation rights, but when you don't have rights as a parent, even if you raise that child. So for instance, in our example, I represented the non-biological parent, and the non-biological parent and the biological parent had been together for many years. They planned this child together. They chose the sperm donor together. They were in the hospital together, etc. They never did get married. And then when the child was 5 years old, the relationship went sour, and the biological mom left and said, "That's it. You can't see our son anymore." So the interpretation that I was trying to get the Supreme Court or the Court of Appeals to adopt was this concept of equitable parentage, which is what does it mean to be a parent? And so various other states have interpreted the word parentage to include functional or equitable parents who are neither biologically related to the child nor by adoption, but have, for all intents and purposes, served as that child's parents from the beginning. So that's a de novo review, does this term parentage include equitable parentage? And that means that the Court of Appeals can look at different decisions and essentially decide what the law means. So that's de novo. An abuse of discretion case, I recently had another custody appeal, but this was between a biological father and a biological mother. So the court, to determine which parent has custody, it's an 8-factor test in Missouri under the statute, especially when dealing, like whether it's joint legal custody or sole legal custody, joint physical, sole physical, although nobody really gets sole physical custody anymore, it really has to do with legal. So the circuit court below had determined that the mom, who was my client, was entitled to sole custody of the child based on these 8 factors. And so the court found according to that lined up with each of those factors. And those factors are the wishes of the parents, the wishes of the child's adaptation to the child's community and environment, et cetera. And then one of the big ones is which parent is more likely to provide frequent and continuing contact to the other parent. So the court determined these factors to weigh in favor of my client, and that's an abuse of discretion issue because so the dad appealed it, and we went before the Court of Appeals, and at that point the Court of Appeals is tied in that they're not going to reopen evidence. They don't re-examine credibility of witnesses. They don't re-examine the evidence. They say, okay, this is what the court found. You're not asking us to change or interpret the law. You're just trying to say, hey, the facts don't match up with what the court decided. And so the Court of Appeals will say, we defer to the lower court for decisions regarding credibility of witnesses and determination of evidence. And so that kind of appeal is very, very difficult to prove. So that's an abuse of discretion. Okay. And in that case, it was brought on the basis of against the weight of the evidence, meaning that the father had argued that the evidence weighed in his favor as the parent who was going to be more likely to allow frequent and continuing contact to the other parent, and not in the mom's favor. But in fact, the Court of Appeals wasn't going to decide that, because they're not going to say, they will, if there's zero evidence, they will, but they're not going to say, hey, this evidence is here on mom's side, this evidence is here on dad's side. Let's reevaluate and see which fact we should find. So that's an abuse of discretion.